everyone. I just wanted to do a quick review on civil procedure subject matter jurisdiction, and this is for the California bar exam. It does help with MBEs, and it also helps with your essay structure. So we're talking about civil procedure subject matter jurisdiction. Subject matter jurisdiction. First, I wanted to explain what subject matter jurisdiction is in the federal courts. So this is federal subject matter jurisdiction. So remember, federal courts are courts of limited jurisdiction, meaning they can only hear claims of diversity or federal question. When a federal court finds that any claim lacks its own independent basis, meaning it lacks diversity or federal question, it must dismiss the claim. Okay, the federal court must dismiss the claim if it's not based on diversity or federal question, unless the court decides to assert supplemental jurisdiction, which I will talk about later on. If the claim is dismissed, so if the federal court decides that it's lacking its federal subject matter jurisdiction, diversity or federal question, then the court can either apply supplemental jurisdiction, and if that doesn't work, then they would have to dismiss the claim, and the plaintiff may choose to assert the claim in state court. Okay? Now, waiver of SMJ, the lack of federal subject matter jurisdiction cannot be waived. This is important. These are sometimes on MBEs. It cannot be waived. It can be brought up all the way to appeal. So if you get an MBE and it has to do with a waiver, remember, you cannot waive FSMJ. It can be brought up all the way to appeal. Personal jurisdiction is different, but for subject matter jurisdiction in the federal courts, cannot be waived. Now, the complaint. Because federal courts have limited jurisdiction, the plaintiff must plead his complaint the exact basis upon which federal subject matter jurisdiction is asserted. Remember, it needs to state in the complaint, diversity, federal question. We must have it in the complaint. If not, then obviously that's not a valid complaint, and the federal courts would have to look upon what they're going to do next, okay? So the complaint, so well-pleaded complaint is what they're looking for. Now, on the bottom, I just put in there state subject matter. So if you get a state subject matter question, like for California, usually the California bar has sometimes throws in civil procedure state of California, and those are different rules. So if it's a state subject matter, a limited civil case is $25,000 or less, an unlimited is more than $25,000, and then small claims for an individual is $7,500 to $10,000. If it's a corporation and small claims, $5,000. You might have to know that if you get a California essay, so I put those rules in there for you. Concurrent jurisdiction and exclusive jurisdiction. Concurrent means that both the federal court and the state court can hear this case. That's concurrent, okay? However, there are certain claims where the federal court has exclusive, meaning only the federal court can hear them. And that is with admiralty cases, bankruptcy cases, patent and copyright cases, and antitrust cases. So those are exclusive only for the federal court, and we do get that a lot in MBEs. Now, federal question, let's move on to what types of claims that this federal court can hear. They can hear a federal question claim. Basically, that means that the case they would like to hear arises under the Constitution, laws, or treaties of the United States. This is not really tested on essays. It would be a short essay if it was, but you might get one or two on MBEs, okay? So federal question. Now, I'm going back to that well-pleaded complaint rule. This really goes with our federal question. If we really want to know, is it a federal question, that complaint has to be well-pleaded. They have to tell us exactly where in the what Constitution, piece of the Constitution they're actually referring to, what treaty, what law of the United States. So it has to be a well-pleaded complaint for a federal question under the federal courts. Okay, the U.S. Supreme Court held that a claim does not arise under federal law unless it appears on the face of a well-pleaded complaint. This means a substantial federal issue must be raised as a legitimate part of the plaintiff's cause of action. The federal issue must be substantial. It must not be frivolous or without merit, which means kind of just a fake claim, okay? So it needs to be a well-pleaded complaint for that federal question on the face of that complaint. It's got to be noticed right away. Diversity. So we went from federal question, and federal courts can also hear diversity causes of action, right? The federal district courts have original jurisdiction over all civil actions where the matter in controversy exceeds Now we need to exceed the sum of 75,000. So it's 75,000 or more for diversity to meet the amount in controversy. Okay. Now that's exclusive of the interest and cost, and the controversy also needs to be between citizens of different states. So complete diversity here. When you write up your essay, you must put in there, how are these citizens diverse, or are they not diverse? So if we have A from California and we have B from Texas, so we have the plaintiff from California, we have the defendant from Texas, that's complete diversity. They're both from different states. Where it gets a little messy on MBEs is when you write it all down and you have defendant 1 and defendant 2, and plaintiff 1 is from California, defendant 1 is from Texas, defendant 2 is from California. A defendant and a plaintiff cannot be from the same state. So that will cause an issue for diversity. So they have to be completely diverse for the federal courts to hear the case. And 75,000 plus in actually the amount in controversy. Okay, 75,000 plus. So 75,000 and 1 penny will work. Aggregation. Now you're allowed to, the plaintiffs can aggregate a claim against a single defendant to meet the amount in controversy. Now we do get that in MBEs, I've seen it. So what a single plaintiff may aggregate, which means put their claims together to meet the amount in controversy. And that way they qualify for that 75,000 plus, okay? A single plaintiff and a single defendant, very important. Now let's just say that there's a claim that comes in that doesn't stand on its own independent basis of federal subject matter jurisdiction, which means it doesn't meet on its own the diversity or federal question requirements for FSMJ. That means that the court can apply supplemental jurisdiction. Okay, so when you go into supplemental jurisdiction, that's another, I would say, another paragraph in your essay. And it must dismiss the claim unless the court decides to assert supplemental. So the court can decide to dismiss the claim, but remember, when they dismiss the claim, they're going to send it off to state court. But usually in our essays, you'll find supplemental jurisdiction will be able to be used. Okay, and that works for, you have to go in there, same T&O, things like that. So now challenges to SMJ. There's a direct attack and a collateral attack. Let's say the defendant wants to challenge the subject matter jurisdiction. Defendant may challenge subject matter jurisdiction through a pre-answer motion, remember your 12 Bs, or in the answer at any other time during the lawsuit, including appeal. So they can challenge it all the way up to appeal or in their pre-answer motion. SMJ may be raised by the court itself or on its own motion, okay? Collateral attack is in the absence of extraordinary circumstances, defendant cannot collaterally attack subject matter jurisdiction in a subsequent proceeding. So in a follow-up proceeding, they may not. Or a collateral attack. Okay, so with that, we're moving on to removal jurisdiction. Now, if we get a lot of essays on removal, and before you can even decide removal, you need to write up your FSMJ first. And then you move on to your removal and remand and all of that, okay? Now, removal jurisdiction, a lot of MBEs, and I think the most important thing to remember is only defendants can remove. Only defendants can remove. I've seen a lot of MBEs where the plaintiff is trying to remove. They're tricky, but only the defendant is allowed to remove. Okay, so if the plaintiff has brought a suit in state court, the removal statute permits the defendant to force the case to be removed to federal district court only if the case could have already been brought into federal court, and that's when we go over our FSMJ first. So if the case is a diversity case and a federal question case and everything looks good, then we can go ahead and the defendant can go ahead and try to remove it. If it cannot be brought in federal court due to not having diversity or federal question, then obviously the defendant cannot remove the case. So you write up your SMJ first and then move on to removal when you see a removal question. Now, if the case is a diversity jurisdiction, the case can be removed only, this is important, only if none of the defendants is a citizen of the forum state. So the defendants cannot be a citizen of where they're trying to remove this case. So if the defendant 1 is trying and defendant 2 agree to remove the case to California, and one of those defendants are from California, it's not going to be able to be removed. The court will reject it. So remember, if none of the defendants is a citizen of that forum state, then it's able to be removed, and it has to pass SMJ first too. And remember, there's another important one. All defendants must agree to remove. So if defendant 1 and defendant 2 say they're willing to remove, and defendant 3 says, I don't want to remove, then it's not going to be removed. All defendants must agree to remove the case, okay? Now remember, you can only remove a case from state court to federal court, not vice versa. Only from state court to federal court, okay? Now, if a non-removable case is removed to the federal court, let's just say in your essay it says that at the end of all this, they found out that the case could not be removed, and it was moved to federal court. What is going to happen then? The federal court will remand the case to state court, back to state court. They're not going to dismiss the case. They're going to remand it back to the state court where it came from. Okay, I see that a lot in MBEs. Now, the notice of removal must be filed within 30 days of the date the defendant receives a copy of the initial pleading. Within 30 days of the date the defendant receives a copy of the initial pleading, unless the case becomes removable later. Then 30 days from that date. So if the case becomes removable later, then it's going to be 30 days from that later removable date, okay? But remember this, a case removable under diversity grounds may be removed only within 1 year after it is brought in a state court. Diversity only within 1 year. All of these 30 days, 1 year, 30 days from the date, I see a lot on MBEs. A case may not be removed from federal court to state court. I said that. You cannot remove a federal case to state court. It's federal court to state court. It has to be from state court to federal court. Now, abstention, this is important too. Federal courts may decline to proceed with a case in certain situations, such as the uncertainty of issues of state law. So a federal court sees that there's uncertainty or unknown issues that are not solved of state law. They may abstain from taking that case on too. So I've seen a couple of those on MBs and a write-up on an essay. Okay, so all these things are related to federal subject matter jurisdiction, and you still have to kind of remember your California rules, which I put at the beginning right here. Limited civil cases and unlimited. Okay, so that's a wrap up for federal subject matter jurisdiction. So if you're going to write an essay, you start with your subject matter jurisdiction, give your definition. Is there a waiver anywhere around there? I would just write up waiver and put there is no waiver, because they like to see all of these head notes. Now the complaint needs to look good. Is it concurrent or exclusive? Make sure that the court can actually hear this and it's not exclusive to only the federal court. Then you start writing up your federal question. There is no federal question here. You move on. If there is a federal question, don't forget to write up well-pleaded complaint rule. After federal question, you write up your diversity. You make sure they're completely diverse, and you talk about your amount of controversy. And if there's any aggregation where they need to put in their amounts of controversy together, then you talk about that. Supplemental jurisdiction, if you have a claim that can hang on its own, then the courts can apply supplemental jurisdiction based on its TNO. And are there any challenges? Challenges are usually only on MBEs, not for write-up. Then you go to the removal jurisdiction, and remember the remand. They will remand it back to state court if it was not supposed to be removed, okay? And that's pretty much the wrap-up for FSMJ. Good for MBEs and write-up. Good luck on the bar exam.